as I try to understand this. I am selling to you. I want to sell to you, and I owe $5,000 to the association for whatever. And so, let me ask you this way first: the association fails to give you anything.
About that 5,000.
That 5,000, and what happens in that situation?
The buyer is not going to be responsible for that quote 5,000. It doesn't relieve the seller of what their obligation is of the money owed.
Okay.
It just means the buyer who paid for a statement of accounts and got incorrect information doesn't now have a change made where they're going to assume that responsibility.
Okay. And if they tell you that I owe 3,000, then you're responsible for the 3, but they lose the 2 that they missed
Against the buyer,
against the buyer.
but not against the seller. That's what
Okay.
I'm trying to emphasize. There's
Gotcha.
still the obligation of the seller regardless. I mean, they already knew they owed the money or should have known. It's only
Okay.
as to the person who's stepping in to the ownership of that unit that there would be a potential loss of a claim against them.
Thank you.
Does that read clear to everyone? So that was where we changed, and what you have happen now is, if you will look at your sheets, starting at the bottom on line 99 through what is known as line 109, that all has been changed, that section has, based upon what I just read to you. Now, let me ask you something. No, you, stop, I'm sorry. It went too far. Through 109. Okay. Were you gonna say something?
Right, where it says on the Willard Amendment, replacing line 110 and 113, as well as 302, what I simply meant, and I didn't have time to type out or put in the rest of what is in 6. 6 is just simply getting renumbered to 7, same as what happens with if you go in the document to line number 302. G is simply being renumbered as E. It's not intended to delete that language. And Ledge Council, I'm sure, can put that in the proper format. Yeah. So if you're looking at the language in the amendment, and all the corresponding sections, number 5 is being stricken and becoming 5 and 6. And then 6, as it currently is written, becomes 7.
So now, let me go on to one quick thing. Mm-hmm. So what we have changed is going back to page 4, is down through line 109. All that portion is being replaced by 5 and 6.
Correct.
Then what you have is starting out line 110, that's to be renumbered as number 7.
Correct.
And that's what that one line shows there, just a number 7 change for that line. Sorry, Mr. Kelly.
No, that's why I was just making sure the only thing changed in that is the number, not the verbiage.
That's
right.
On number 6. So at that point, do you have other changes before we get to line 291?
No, sir.
So you have the same thing that we talked about as far as that insurance clause and the other provision. And now we go over to line 291. And now we're dealing with the residential type associations.
Correct.
And what we have at 291 is again the same thing. They had it as letter F. It now be F and G as opposed to numbers. And then that starting the next line, association's authorization is changed to
E.
no H.
Yeah. Sorry.
Sorry, but change that bottom be H. Small letter H in parentheses. Those were the changes, and I'm now open for discussion among the members of the committee. Yes, sir. Mr. Caldwell, or no, Mr. Wells?
Hey, yes, sir. Mr. Chairman, the Question, does this new version, does that contemplate allowing for an adjustment based upon CPI for the fees, or are they fixed
No, sir.
permanently?
We had that discussed at the last meeting, and we felt if there's a need for changes, as we have with so many fees in the code, we just have the ability by the General Assembly to modify those fees in the future.
And then secondarily, would the chair be amenable to considering a delinquency fee, so that if there are delinquencies owed, that there can be an additional charge to make sure that they've gotten all of those delinquencies?
Well, the delinquency fee would really address the bylaws, the covenants of the association, as opposed to this matter. All we're addressing in the provision here in our code is a party buyer seeking to get information from the association as to what are, as we call this letter of account, what are the things they need to know to go through a closing. But your fees you're talking about, as far as late fees, all that's done within the bylaws of the association itself.
Okay, and then, because I thought we were going to try to mirror this after the Florida law, and that that was from the first meeting, so I know things have,
Right.
and I've missed a couple of the meetings between, so.
The Florida law calls for a fee of $250 for this statement of account. What we have provided here is a payment of $200 plus the ability to be paid $50 for an expedited letter. So it's not that much out of line with what Florida has, and I think most of these might have come about needing an expedited letter, but that's, again, something any member can offer as amendment to the proposed bill.
Ask a question,
You
Mr.
want-
Chairman.
Yes,
Would you be okay if we made it the same as the Florida one?
that's whatever you want. It's the wishes of the committee.
I always care about what the chair thinks.
Well, I felt this was a fair amount from the input I've had from, not only the realtor side, the closing attorney side, and the association side, to try. They could not come to an agreement. They were unable to, and we never got any proposal, frankly, from the association side. And I felt what the realtors came in with was really, frankly, lower than I felt was appropriate. What I tried to look at, and I tried to weigh, has been how much time, from a clerical standpoint, may be involved with a party pulling together the information that you have being expected in this document. And we had discussions about that at the last hearing with the input of members of the audience. And the argument still was, I know the association would like to have a higher sum, and I'm sure the realtors would like to have a lower sum. So part of what we do here is come to a decision, and maybe one that doesn't make everybody happy. You want to push your button? Yes, sir.
Going back to the first meeting, it was clear to me that the subcommittee ferreted out some of these issues and I think some of the misinformation that's been out in the hallways. And first off is that there is a cap in state law. It's $10 for this statement of accounts. The statement of accounts is defined. It only deals in arrears under current law. And so I like the idea of expanding this to define what documents we're going to cover and to be more inclusive of those documents that are necessary for the closing to occur. And because of this expansive list, I also recognize that there's a cost in putting these together and to provide those documents, and that in that preparing those documents, a fee is reasonable. As the chair has said, the question is, what is the number? I always like to be better than Florida anytime we can and beat them out. And I think
Well, I'm not sure what Alabama does either. We'll check another sister state.
that's right.
I mean, you'll find different amounts, I'm certain, in most every jurisdiction.
And my inclination would be to go. I think that this has been debated and vetted in our sister state, Florida, and as well as I'd like to have a lower rate than they do, I also think that there's probably some market-based information that has driven that to that number.
And as I said, there would be an opportunity for amendments. Any further comments from members of the committee or questions, discussions? All right. The chair will now entertain motions on House Bill 410 as LC 288757 ERS with the amendments as offered, called the Willard Amendment on the 8.5 by 11 page. Motions do pass. Seconded. Is there any discussion on that motion? If not, are there any amendments to the motion? There being amendments, all right. State your amendment.
Mr. Chairman, without having the exact line numbers in front of me, but I will try to do the best I can.
I'll give you time.
Thank you.
I think it's over on,
I'll state the
it's on line, starting 110,
Yes.
section 6.
At line 110, there's a statement of the fees that the state will impose. Okay. At line 111, the reasonable fee that is set for the preparation is $200, and I would like to amend the bill wherever the 200 appears
Two times.
two times to be 250.
You have a motion and a second on the amendment to change the amount of consideration for the statement of account from 200 to 250. You got your button? Is that Mr. Kelly?
Thank you, Mr. Chairman. I'm trying to get some clarity from the author of the amendment if he intends as well to offer an amendment that would deal just when there is a delinquency. Okay.
I say the amendment, I mean the delinquency doesn't address the need in state law. That goes as to each association. Now, if you wanted to put a limit to how much they could do on a delinquency, that'd be, perhaps something to go in the state law, but we have not, to my knowledge, addressed that in state law at this time. Maybe somebody tell me I'm wrong about that, but I didn't go through the entire section of the condominium code and the other looking at that, but that's not something we have exercised dominion over. All right. Any discussion on the amendment, members of the committee? And I'll state my position before, and that was the fact that we are trying as a committee to come to a compromise that the parties were unable to reach. Although I know the realtors had a desire for a lower sum, we had never received a sum of money. I knew what the Florida amount was, and my position was to take the amount as 200 and then the opportunity which would be there for 250 because of the expedited amount. As it stands now, what you'll have is the ability to get the 250 with this amendment plus another 50, which would be $300, and that's usually paid by the party who may be really depends on what the contract calls for. But I think the current language in the Board of Realtors contracts calls that to be paid by the seller as an expense of the seller. So he's having come out of his closing proceeds. Mr. Kelly?
Just another question, maybe to the author of the amendment. Do we know what the expedited fee, if any, is in Florida for an expedited basis?
I believe the amount is $100, if I remember correctly. But it was a quick skim when you handed it out to us before. But I'm not offering an amendment to change that number.
You would simply be going 250 and then
250, and that's my only amendment that I'm offering.
Thank you.
All right. Any further discussion on the amendment? Chair will call for the amendment, Welch Amendment. All in favor, raise your right hand. We have 4. All opposed, 1. 4 to 1. 2. I'm sorry, so we did not have a tie. 4 to 2. The amendment carries, so the fee amount is changed to $250. Any further amendments to the bill? There being no further amendments, we will call. There's 3 times, I think, where the 200 sum is mentioned. Is that right?
Yes, sir. Do you want to amend that?
I had that already added as a part of the main motion. I said the main bill plus the Willard amendment is what we had a motion on.
Right.
Correct? Thank you. We have now the vote on the main motion, which is a do pass as amended by the Welch Amendment to House Bill 410. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. It's a committee substitute. Amended as a committee substitute. Okay, we're down to next, and I think our last bill is 410. Get my sheet up here. 745, excuse me. 745, that's the bill Mr. Holcomb has. And Mr. Holcomb, we've had discussions and some modifications of this bill. You have before you the bills, House Bill 745, and it's also now in the breast of the committee. We've already received public comment. The thing that we're looking to have changed is beginning on line 16 through 20, and we try to clarify under the civil proceedings, a civil family violence order. You have two types of proceedings. One is a civil and the other is a criminal family violence proceeding. So we're addressing here just a civil proceeding, and we want to make it clear that under that type of proceeding where you have a party going in, a person who's claiming they have been the victim of family violence, and getting what we call the initial order, an ex parte type order, for a temporary protective order, if they're seeking then to use that as a way of canceling out their obligation on a residential lease, that in addition to that ex parte temporary protective order, they're going to need to have a police report as a backup information. We felt this was necessary because from the chair's posture and position on it, you have someone who is now a individual who is unilaterally seeking to have a cancellation of a contract with a third party who has not been a party to this family violence potentially, but is going to have certainly an interest in the loss of a rental contract being canceled. So we put into the language, divided, I'll read it out. Under civil violence, order means A, any protective order issued pursuant to Article 1 of Chapter 13 and Title 19, provided that the respondent was present and had notice of the hearing that resulted in the issuance of the order, which could come to pass with both the victim and the person perpetrating the injury, or B, any ex parte temporary protective order issued pursuant to Article 1 of Chapter 13 of Title 19, provided that it is accompanied by a police report showing a basis for such order. We had that change. And then on the next page, to again clarify the language, there was some confusion when you read what would be under Section B, the termination. It says a tenant, and I'll read this through with all the changes. The tenant may terminate his or her residential rental or lease agreement for real estate effective 30 days after providing the landlord with a written notice of termination when a civil family violence order or criminal family violence order has been issued, 1, protecting such tenant or his or her minor child, or 2, protecting such tenant when he or she is a joint tenant or his or her minor child, even when such protected tenant had no obligation to pay rent to the landlord. And the purpose of that was we had the language talk about having occurred on premises. I don't think there was necessary to be family violence on the premises where the rental is located if there's going to be a protective order issue. So we clarified that part. And in C, We made one minor change I'll read to you. The notice of the landlord pursuant to subsection B of this code section shall be accompanied by a copy of the applicable civil family violence order or criminal family violence order and a copy of the police report if such order was an ex parte temporary protective order. So again, wanted to clarify that if it's ex parte, you've got to have that police report for it to occur. Those are the changes. And Mr. Holcomb, I'd like to hear from you, if I might, as to your thoughts and position on House Bill 745.
Thank you, Mr. Chairman. Thank you very much for your willingness to work hard on this and to consider the various feedback that I provided, and I support the current version and very grateful for your interest in this subject matter and your efforts to improve the bill.
All right. Do we have comments from other members on the committee? Mr. Welch.
Yes, sir. Mr. Chairman, I wanted to thank you for clarifying the language on the second page in lines 34 through 36 and also at 31 and 33 through 33. I thought that was, I don't think we were contemplating that it was isolated, this violence is isolated to the particular premises, but the endeavor here is to protect the individual who has been abused and enable that person to remove him or herself from what is a dangerous situation and change residence as needed. And I thought that was a good catch. And so I support this measure.
Right. Mr. Fleming.
Thank you, Mr. Chairman. I've been thinking a lot about your bill, and
Not my bill.
I'm looking at him.
Oh, him. Oh,
I'm
you said
looking,
Mr. Chairman.
I'm looking past you.
Got you.
I said, thank you, Mr. Chairman. I'm sucking on a cough drop, so I'm sorry. Nobody, it's obvious that the landlord who was about to get the short end of the stick didn't do anything wrong. But there is a party here that did do something wrong. It's the party against whom the order of the court is levied in this sense. Do any states, to your knowledge, make that party liable for the landlord's losses? Not that I'm aware of. Wouldn't that be a good thing if we could figure out how to do that?
It would be, and I'm open to continuing how to do that in terms of a conversation if you'd like to.
As I read through the bill, I was trying to figure out an easy way to do that, and I was not successful. But I would like this party who has now caused really an innocent bystander to suffer some harm too, not to the extent probably that the domestic violence victim is, but nonetheless, you're a landlord, you're doing your job, you run a clean place, and all of a sudden some bum causes you to have to deal with a significant problem. That bum ought to be held responsible for the damages he's caused to that third party.
Right. Follow up, of course, if that quote bum is on the lease,
Exactly.
they're not excused from the lease.
Correct.
You're looking for a situation where that bum is not on the lease,
Right, because
but the
then,
woman
yeah,
or
you got
man
someone to
who
go
is on
after
the
him.
lease is the one who's been injured.
Right.
And I don't know how you're going to contractually put somebody in an obligation like that constitutionally.
And I don't know, except for the fact a judge has some ability to do things with protective orders because it's a quasi-equitable situation, I think, is it not, Mr. Chairman?
It's possible, but he can levy fines.
He's certainly about to break a contract.
Yeah. He's based on the law that we are enacting.
If he can break one, how come he can't make one?
He's
I
not.
guess is
He's
what I'm
not
saying.
breaking it. The law is giving the authority of the individual who has been injured the right to remove their responsibility from that lease.
Right.
I don't think
Well,
we're not putting, and I don't know if we could put anything in the law that says because of what you've done as an act, you now assume a position, position of being responsible for a contract. Because constitutionally speaking, I'm not sure. Maybe my learned counsel, Julius, can tell us.
Yeah, I think that I don't see how, if the party is a party to the contract, how he or she could be held responsible for obligation that they would be contracted.
Well, the landlord is not a party to the offense that has occurred, which is causing his
Yeah.
damages.
But I guess in this instance, it's the contract that's on paper, not something.
If we figured out a way to do that, Mr. Holcomb, would you be open to an amendment to?
Yes, sir.
To do that at a later time?
Yes, sir.
Thank you.
Mr. Strickland. I'm kind, sorry.
Wrong Henry County.
Wrong. That's right. Excuse me.
Or just refer to me as Eagles Landing. Educate me on these protective orders. Who are they signed by? Is it what judge? What is it state? I mean,
They're
what
signed by a Superior Court judge.
Superior Court judges? Are these? If you do a background check on someone, do these show up in a background check?
Family violence orders are something that becomes a part of public record, and yes, they would show up in a check.
Like an employer's check? I mean,
Well, I mean by any court records are open to assimilation and put on. You have several national firms that do assimilation of court records. I think Equifax does. So yes, they could pick up the information that way because it is a public record.
I was just I was just curious if it was, if an employer runs a employer, on an employee, potential employee.
Mhm.
Do we know if that would show up on that report? Any type of reporting? That's my question. I don't know. It
I
would.
think there's the opportunity for it to show up. I can't tell you it's going to always show up.
Okay.
It just depends if it's been assembled by
Right.
somebody who takes those records. and
I
puts
guess
it-
my concern after going through this is how is this going to protect an individual? How is this actually going to protect an individual unless they go into hiding? How is it?
The harmed person.
Yes.
That's the I guess theory is that they by getting away from the individual who caused the harm, they need to change their place of living so the individual who caused that injury doesn't know where they live now.
Mm.
That's the I think quote theory behind it. Anything further, Ms.
No, that's good.
Rutledge? Yes, sir, Mr. Welch.
Thank you, Mr. Chairman. Just to follow up on that question, individuals also may find themselves going to a shelter, and then they may be in the shelter for a extended period of time. They may find themselves going back to their parents' home or to a friend's home, in which case they're incurring expenses as associated with the lease to their detriment, which also makes it more difficult, especially if the individual is not necessarily the breadwinner of that relationship or does not have exceptional employment. It makes it difficult for them to carry that burden and cost. So what you're doing is by passing this legislation, you're enabling that individual to retreat from the situation and to find shelter in another location without that additional financial burden. And that is a significant change in our law. I mean, there's no question about it. But I did want to point out to the committee and to the public that this enactment, if passed, does not apply to any existing contracts. It only applies to contracts going forward.
Sure.
So there is no constitutional infringement of those contracts as
Yeah,
this
if
bill
it
is
did for
written.
the past, there would be a problem.
Yes, sir.
It'd be constitutionally voidable.
Another question, Mr. Chairman, or Mayor.
Yes, sir.
So when the judge enters this order, does he need to find that contract should be voided because of the potential harm to the person?
The Act doesn't call for that.
Why not?
Well, it just doesn't. That's the way it was presented to us.
I mean-
I'm saying the judge doesn't make a finding of the severity or reason why or not there should be a voiding of the lease agreement. That is only under the terms of this statute between the victim who's been harmed and the landlord who has to be given the order and a police report if that's called for as an ex parte order.
In that we are about to make a pretty significant change in our law as far as property and landlord tenants and their relationship, why shouldn't the judge take into consideration if he needs to do that because these circumstances require for it?
I would know, but might ask the judge that's had these things. Mr. Caldwell? Judge Caldwell?
Somebody's got to ask for an order. Why don't they say, and Your Honor, also, will you put in there this because?
Judge Caldwell, address your question to Judge Caldwell.
As I
if you
read
would.
the bill now and understand it, one does not have to point out to the judge, Judge, I have this problem. I don't need to go back there, and here's why. Would you allow me under this code section to be done with that lease? You just have to get an order saying, a protective order, and that automatically applies to you whether or not you need that protection or not. I mean, it gives you the ability to break that lease you entered into, even if you don't need that protection, because there will be circumstances where you do need it, but there could be circumstances that you don't. And if you're going to interfere with this area of the law, make this change we're about to make, you do make someone at least ask for it.
Well, I think that the only way that you could do what you're saying.
Pull your mic around, if you would, Judge, so we can get your good comments.
I think, Chairman, the only way you could do what Chairman Fleming is asking for is when you have that final hearing. And see, this one is saying within 10 days, so this is talking about after a temporary. Well, you can get the ex parte. Basically, I've never known of anybody that's refused to sign any of them. Of all the hundreds I signed, there was only one, and that's because a lady came and said, my lawyer told me to come tell you that my husband was going to hurt me so I could get him out of the house. Other than that, nobody ever refuses them. So I don't think you could do what you're saying until you have that 30-day hearing. And that, by this, then you have findings of facts and so forth and so on. So then you'd have to do what you do about this 10 days hearsay. I think you could do what you're doing, but I think it would have to be at the final hearing, that 30-day hearing that you got to have. I don't think you could do it initially.
All right, thank you. Any further comments? The chair will make a sort of a closing statement about it. I think of only one other instance in our law that we have the opportunity of a party to void a lease contract, and that's when you have someone who's in the military, and that person in the military gets transferred, and as a result of the transfer, of course, they can't continue living in that home or residence, where it may be, and so we've given them that right to cancel the lease. But the difference is the landlord knows that person's in the military from the time they make the lease. We don't have that in the situation of a person who owns property and rents it to someone, that they're going to anticipate there will be harm caused to someone at a future date. And so I've always said we're putting this owner of the premises in a very unusual situation, expecting them to, it's not always 100-unit apartments we're talking about some people who have 1 or 2, 3 homes they might be renting out as a residence, and all of a sudden, and that's their livelihood. And now you have an individual unilaterally saying, I'm breaking my lease and I've got this ex parte order, and yes, I got a police report where something happened, and now the harmed person is financially harmed, is going to be the owner of the property. So I want you to weigh that as we look at this. What should be the policy of the state under this unusual format? Any other comments from members of the committee? If not, you do, Mr. Holcomb, excuse me.
Yes, sir. Mr. Chairman, very briefly, in terms of the potential harm is there may not be any on the landlord, because once the notice is given, then they can start to work to re-rent or release the premises. And so what's being waived is the early termination penalty. So I agree with you in terms of if they can't find somebody and the lease is unfilled, but it is potential or it is possible that they would not be harmed if they were able to find a new tenant quickly.
Understood.
Thanks.
We have closed off then the comments. Do we have a motion for House Bill 745? Is a motion due pass to that? Do we have a second? It has been seconded. Is there any discussion on the motion? Further discussion? If not, the chair will ask for any amendments. Are there any amendments proposed? There being no amendments, we'll call the main question, which is a due pass, House Bill 745 as a committee substitute. All those in favor signify by saying aye. Opposed, like sign. I hear only one vote. Eagles landing 2, Mr. Ross. 2. That's 1, 2. All right. So we have 4-2. Bill passes the committee with a recommendation and is a committee substitute. I thought you did. No, you did not. Okay, sorry. I'm sorry. I misunderstood. All right. That's the end of it. If anything further come before the committee today? I want to stop one, everybody. We have a former House member and chairman of this committee sitting with us today, Mr. Tom Bordeaux. Judge Bordeaux, probate judge of Chatham County. Well, I've been trained for 14 years at it. All right. Meeting adjourned. That's a fourth.